Ready to make a real impact every day? Join the Active Day Home Care team and help clients maintain their independence in the comfort of their own homes. Make a difference in someone's life as you provide essential daily assistance and protect their health and happiness. Earn up to $20 an hour and enjoy additional perks like optional daily pay, 401k, paid time off, ongoing educational training, and more. Join a team that values care, compassion, and your professional growth. Visit activeday.com to apply.
Hello and welcome to True Crime and the Court of Public Opinion. I am Alexis Knight. And while you've been waiting for Diddy and Reed, while social media floods your feed with TikToks from the courthouse, paparazzi shots outside arraignments, and think piece commentary on every eyebrow raise and outfit choice, something else is happening. Something more dangerous, more permanent. And it's happening in silence. Right now, while the public is literally glued to the latest celebrity meltdown or live stream trial, real cases, things that affect your rights, your safety, your drinking water, your body, are playing out in near total obscurity because justice doesn't trend, does it? Doesn't get a Netflix deal. Doesn't come with filters and stylists or handlers. It happens in courtroom basements, behind redacted memos, and under news cycles designed to make you forget what actually matters. So while the headlines are shouting about Karen and Sean, here's what you weren't supposed to notice, not really. That over 2,000 women are suing Uber for sexual assault in one of the most underreported corporate accountability trials of our time. A former Houston narcotics officer finally being tried for faking a warrant that led to the death of 2 civilians and exposed a decade of police corruption. The UK closing a legal loophole that had allowed adult men to consent as a defense when raping children under 16. That's not ancient history. That's happening. And a national poisoning scandal in the United States where 97% of Americans, yes, you, already have the chemicals in their blood. And no one told you. And no one gave you the choice. This episode is about the justice system you aren't seeing, the trials that don't get the hashtags, the stories that will not be clipped for your algorithm. Because while everyone's watching the same courtroom cameras, other trials are happening in the dark where the stakes are higher and the silence is intentional. So yes, while you wait for Diddy and Reed, here is what else happened, and none of it should have been quiet. Let's get into it. Well, if you never heard of MDL 3084, you're not alone. And if Uber has its way, you will stay in the dark. Because while you're waiting for Diddy's settlement terms and watching Karen Reed on live stream, playing on TikTok, more than 2,200 women are quietly fighting in federal court, claiming they were assaulted by Uber drivers and that the company knew it was happening. This isn't a lawsuit for attention. It's not about going viral. This is over 2,000 women saying the system failed them, and Uber let it happen. This is MDL number 3084, a massive multi-district litigation effort in the Northern District of California. Presiding Judge Charles R. Breyer, it consolidates more than 2,200 lawsuits by women who say they were assaulted verbally, physically, sexually by Uber drivers across the United States. Here is what they're claiming. Uber fast-tracked driver approvals, skipping fingerprint-based checks that could have caught red flags. Uber allegedly ignored complaints about dangerous drivers and let them stay on the road. Internal warnings, flagged by safety teams, well, those were allegedly buried to protect profits. It's all about the money these days, guys. Everything. It's incredible. Uber, for its part, denies responsibility. Of course. Of course it would. its core defense? We are just the platform. Drivers are independent contractors and we are not liable. But the plaintiff's attorneys say Uber had every opportunity to build real safety into its system and chose not to. And even worse, some of those plaintiffs claim their own reports were dismissed or deleted. One woman says she found out her attacker was still driving months after she filed her complaint. And here's the power move. These women aren't filing one big class action. They're each pursuing individual cases but consolidated under the MDL for efficiency in discovery. They've even got a settlement master now. Heard of that? Retired Judge Andler, who's beginning negotiations behind the scenes. Yeah, some things you might not know about. And Uber, well, they're playing it cold, and of course they would. They've fought subpoenas to background check companies. They've objected to producing internal app data. They're trying to contain the blast radius because once these stories go public, it's game over for the we're just a tech company defense. This could start something with other things as well. First bellwether trials are set for December 8th, 2025. Put that on your calendar because you will forget by then. Absolutely. I'll be here to remind you. Uber is treating this like a war, and the women who filed these suits, they're betting their silence is finally over. Because this trial isn't just about Uber. It's about every gig economy company that hides behind user agreements and contractor loopholes. If Uber walks away from this without consequences, what happens next? Does Lyft double down on its own legal shields? Does DoorDash even bother verifying its drivers? Does any platform take user safety seriously anymore, or just wait for the payout? And what happens to the thousands of people who have already been hurt? You know there are so many more who just don't have it in them to come forward. This MDL is a test case for the future of tech liability, so pay attention to this one. It's a question we haven't answered yet. When does a platform become a perpetrator? Because if Uber had 2,000 reports of faulty brakes, they'd have issued a recall, wouldn't they? But 2,000 reports of assault? They issued a quiet statement. This isn't about tech innovation anymore. It's about institutional indifference and whether anyone in Silicon Valley can be held accountable for what their apps unleash in the real world. The courtroom clock is ticking, and here's what's coming next in the Uber MDL. Discovery ends September of 25. Okay, that's the deadline for both sides to turn over everything. Internal reports, background check records, app activity, and even social media logs. Bellwether trials begin December 8th, 2025, as I mentioned. 6 cases have been selected as a legal test group. These are the ones that'll go to trial first, so juries can weigh the evidence and Uber can feel the heat. If even one jury rules against them, settlement talks go nuclear. Sources say Uber's legal team is already bracing for payouts in the hundreds of millions, with some individual settlements likely to cross the 7-figure line. But Uber's not just trying to win this trial, they are trying to win the narrative, okay? Because this kind of a thing can change so many things. They want the public to believe that this is something rare. They want investors to believe it's manageable, and they want you to keep tapping that button and not think twice. And that's the real problem. You don't see the danger until it is in your back seat. The fallout of this case won't just determine Uber's financial liability, it will determine how far a tech company can go before being forced to care about you. Because if the court decides Uber isn't responsible for vetting its drivers, then no one is, no one will be. The next time you step into a stranger's car, that's exactly what it is. You're not just trusting a 5-star rating. You're trusting a system that already ignored over 2,000 women. All right, and then let's move on to this one. Dead on arrival. The Harding Street raid trial begins. A fake tip, a forged warrant to civilians gunned down in their home by a narcotics squad. Now, 5 years later, the federal government is finally putting a former Houston police officer on trial. Not for a bad call, but for manufacturing the entire reason to knock on the door in the first place. Yep, you've probably heard the official line. Officers were executing a no-knock warrant at a suspected drug house. Have you heard of that before? Because that happens. And maybe you thought, hey, it's another intense raid. Maybe they found something. Maybe it was tragic in Houston, but justified. You were told the officers were acting on a credible tip from a confidential informant that the couple inside, Dennis Tuttle and Regina Nicholas, were dangerous, possibly armed, and that drugs were being sold from the house. And when the shooting started, you were told they fired first. That's the version Houston PD ran with in the first 72 hours, but it collapsed because there was no informant. There were no drugs for sale, and according to internal investigations, there was no justification for that warrant at all. This wasn't a bust gone wrong. This was fraud wrapped in body armor, and someone had to pay for it. So what is this? Well, it's the trial of Gerald Goines, a former Houston narcotics officer now facing federal criminal charges for civil rights violations, obstruction of justice, and falsifying documents. Gerald is accused of fabricating an entire probable cause affidavit, the document used to justify a no-knock raid. And that was on January 28th, back in 2019, that left Tuttle and Nicholas dead in their home. Here's what we now know. Gerald claimed a confidential informant bought heroin at the house, but when pressed, the informant said he'd never even been to that location. HPD later admitted the drug evidence was planted. How does that feel to you guys amid the Karen Reed trial? Internal documents show he had a pattern of cutting corners, misreporting surveillance, and manipulating paperwork to make arrests stick. Yep, and this gets darker. Regina Nicholas was shot while unarmed. Dennis Tuttle allegedly returned fire, but experts now question whether his shots came after the initial barrage. The raid team fired more than 50 rounds. The home was never a known drug house. Gerald wasn't acting alone either. 11 other officers were eventually charged at the local level for their roles in the botched raid or for covering it up after the fact. But his federal trial is the centerpiece. It's the one that could make this case national. So you might hear about it, but you're hearing about it now. And that trial's finally here, okay? Federal prosecutors allege that Gerald knowingly submitted false statements, lied in reports, and created the illusion of danger in order to justify a high-risk raid. And his defense, that he was working in good faith using the best information available and that any discrepancies, they were just honest mistakes. But let's be real, this wasn't sloppy police work. This was engineered violence built on a forged document and a fake narrative. And it didn't just destroy one family. This detonated trust in the entire Houston Police Department's narcotics division. And as a result, over 160 convictions tied to this man have already been thrown out. More are expected to follow. This is a system unspooling in real time, guys, and it all started with a lie that led to a door getting kicked in, and then people ended up dead. This was not just a cop having a bad day here. This really was an entire department running on fake paper, unchecked power, and the kind of internal loyalty that prioritizes brothers in blue over truth, accountability, and even dead civilians. This matters because if Gerald hadn't been caught, this would have been swept into the same folder as every other raid where the bodies don't get up and the officers write the report and no one asks questions. And here's what no one wants to say out loud. This wasn't rare. Okay? This guy had been doing this kind of thing for years. He was considered a star in his narcotics unit. He made big arrests. He closed cases. He fed the department numbers they could wave around at press conferences. And in return, he was protected. Just like you see on TV. You know how they always say it's not like it is on TV? Hey, this is. No one looked too closely. No one followed up on the informants. No one checked if the warrants held water because the system wasn't built to slow down a cop who's producing results. The Harding Street raid matters because it forces the question, how many more of these kind of cops are out there? It pulls the curtain back on an uncomfortable truth. Departments do not always reward accuracy. All right? What did they reward mostly? Dollars, arrests. They don't audit power. They insulate. And when that power leads to death, there's rarely a courtroom and almost never a conviction. So yeah, this case matters, not because it's something new, but because it's finally being treated like the crime that it is. And it matters that it's going to federal court because local DA's offices have too often been handcuffed by their own proximity to the departments they are supposed to check. Okay, that's why these systems, they just stop working eventually. This is one of the rare moments when the federal government is stepping in and saying, hey, you do not get to write fiction, kill civilians, and just walk. This trial begins on September 25th, 25. All right, so September is a month to watch so far. Charges include deprivation of rights under color of law, falsification of records, and obstruction of justice. More than 160 convictions tied to his police work, they've already been vacated. That number is likely to rise once more records are unsealed during trial. The city of Houston faces ongoing civil suits from the families of Nicholas and Tuttle, as well as others impacted by Gerald's fabricated cases. Early estimates say the total payout could reach 10 to 15 million. That's a lot of millions I've already talked about just in this episode. It's a lot of money going around. Internal reforms have been promised. We'll see what happens, but the trust is already gone. The damage has been done. A new oversight board was formed. No-knock warrants were supposedly restricted. But okay, here's the question. What if this guy does walk? What message does that send to the rest of the country? To every city where narcotics squads still operate under the radar with battering rams and blank check affidavits. It's a tough business. But this isn't just about one raid. It's about whether the system is going to be willing to convict its own architects. Whether I thought they had drugs, is enough to actually kick in a door. Whether an innocent woman shot on her couch can ever get justice when the badge is allowed to write the narrative and then destroy the evidence. We've seen this kind of thing. We've heard this kind of thing happening. This trial isn't just overdue. It's a test of the justice system and of public tolerance, really. How long we're willing to look away from legalized lies with government-issued guns. So pay attention to September. What gets decided in that courtroom won't just be about Gerald. It'll be about what every department thinks they can get away with next. And hey, think about this. You might not see it on the front page, but what if the next door they kick in was yours? All right, how about this story? The consent that was never real. UK's crackdown on grooming gangs. Yep. After decades of failures, denials, and systemic blind spots, the UK is finally changing the law because too many adult men claimed a 13-year-old girl consented, and the courts let them. What did you think of this? Have you heard of this? If you did, you probably assumed the law was already clear. Over there, you thought children can't consent to sex. Period. You believed any adult having sex with someone under 16 was automatically guilty of rape. Maybe you assumed if the police knew about it, they'd stop it. Or if the courts saw the evidence, they would lock him up. That's what most people in the UK believed, too. But then the stories started breaking. Stories of girls, some as young as 11 years old, being trafficked by groups of adult men, passed around, abused, and then discredited by the same institutions meant to protect them. Instead of treating them as victims, police and prosecutors labeled them troubled, promiscuous, or unreliable. And when it finally came to trial, the defense lawyers looked a jury in the eye and said, "She consented." And too many juries believed it because the law allowed it. In case after case, the argument wasn't whether sex occurred, it was whether the child seemed willing. As long as the victim didn't physically fight back or scream for help or have a history of innocence, that argument sometimes actually worked, and the men walked. Come on, guys, this isn't a new crisis. Where have you been if you don't hear about these things? It's a decades-long pattern of systemic failure. I'm talking UK now. The epicenter, towns like Rotherham, Rochdale, Telford, where hundreds of girls were groomed over years by organized gangs of mostly adult men, while local police and councils and even schools looked away. In the most infamous case, it was a 2014 inquiry into Rotherham, revealed that over 1,400 children had been sexually exploited between 1997 and 2013. The girls were often from foster care or a troubled home, deliberately targeted because they were easy to discredit. They were lured in with affection and alcohol and intimidation and then trafficked and silenced. And when they tried to report this, they were dismissed. Some were even arrested. Many were told by police that they were choosing this life. And even when cases went to court, the defense had a nuclear option: consent. Because under UK law, while sex with someone under 16 is technically illegal, the existence of consent could still weigh in the legal argument. It could still be used to challenge mens rea, the defendant's mental state, their intent. That gray area was all many defense attorneys ever needed to poison a jury, and it was an absolute gift to traffickers and predators and every institution that wanted to pretend these girls weren't worth protecting. But now, after years of outrage and shame and growing public pressure, the government is finally moving. As of June of 25, right now, UK Home Secretary Yvette Cooper has announced, we're tightening the law so that no adult can use the defense of consent when charged with raping a child under 16. It's a shift many advocates call decades overdue. How can you even argue this? This law will now explicitly remove consent as a legal argument in underage rape trials. And it's not about cleaning up future cases. The UK is launching a national inquiry into institutional failures. This is set to run 3 years, covering police departments, child protective services, and local councils, asking the one question no one wanted to face: why did we let this happen for so long? With so many things. People get away with things when we have ancient systems. We're used to our digital and our fast and everything knows and it checks. Not when it's on paper, not when it's old school. It allows for crimes to happen. Look what's happening with Doge. Now we have the same types of things happening across the pond. It's time for people to catch up, to the modern day and stop allowing crimes like this. I mean, this matters. It should have been completely obvious. This should have been illegal in spirit, practice, in every courtroom. What is going on? It wasn't. It wasn't clear. And predators knew it. They knew if they picked the right girl, someone in foster care, someone already labeled a problem, they had a better chance of getting away with it. They knew that if she didn't fight hard enough, or if she came back the next day, or if she had alcohol in her system, they could argue that she wanted it. Discredit. And the court might believe them. And that is what has been on trial for decades, and no one wanted to admit it. That's atrocious. Not just the men who groomed these girls, but the entire infrastructure that treated child victims like unreliable witnesses to their own exploitation. This law change matters because it finally closes the door on the most grotesque legal defense, that a child can choose abuse. It matters because it forces a reckoning with every official who failed to act, every police chief who ignored the patterns because they're out there, and every social worker who dismissed a 13-year-old's bruises as drama. And of course, every single politician who stayed quiet to avoid offending those sensitive communities. And yes, it matters that the UK is doing this now, but it also begs the question, what did take so long? If a 13-year-old girl being raped by a 40-year-old man was not enough to force change in 2014, you really have to ask yourself. And then ask again, what's finally making it happen now? What could possibly make this happen now? Was it political pressure? Cultural backlash? Media exposure? Or was it simply that the shame got too loud to ignore? Well, we don't get to know, and whatever the reason, it does matter. But, the delay matters too. The new legal reform explicitly banning the use of consent as a defense in child rape cases under age 16, it is now set to be written into law in late 2025. More things happening later this year. It will change the way future cases are tried across England and Wales. It removes any legal ambiguity about whether a child's behavior can be interpreted as willingness for sexual abuse, and it ends the courtroom gaslighting that has been used to excuse decades of abuse. There's that gaslighting again. We've been talking about it here. It's happening around the world. And this also kicks off something bigger. A 3-year national inquiry. This is big. Launched by the UK government into how and why cases like this were allowed to happen unchecked for so long. And this inquiry will examine police departments accused of ignoring grooming reports. It will investigate local councils who turned a blind eye and review failures in child protective policies and call out the racism and the classism and the institutional cowardice that let the young girls be branded as liars while their abusers walked free. And it won't just be historical. Already new accusations are surfacing. French arrests are being made in areas where survivors say abuse is still ongoing. It's just less visible. Some of the same men who were investigated in the early 2000s were never charged. And they're still walking around. So what comes next? Well, that depends on how honest the UK is really willing to be. It's a nice show so far. What will happen next? Will they treat this inquiry as a PR cleanup? Will they actually name names and fire some leaders and rebuild the system that failed? Because here it is. This begins and everyone looks away like, oh, this is being taken care of. But then it all dissolves, so we need to stay on this one. Will survivors finally be believed? Will prosecutors go after cases that were dropped and buried and mishandled? Will justice finally arrive? Or will this just be the latest symbolic gesture? One more apology with a fresh coat of paint, but nothing really happens. All right, the damage is done, but what happens next tells us whether we as a people actually learned anything from this. Is change possible here? And let's move into this. Poison in the bloodstream. The EPA on trial over forever chemicals. All right, the most dangerous chemicals in your water were not put there by accident. And people who did it knew exactly what would happen. And now the courtroom is the last place they can be held accountable. When do we ever get to have good drinking water everywhere? I mean, you probably assumed your drinking water was tested and regulated and safe, like someone told you that sometime. But you knew it wasn't perfect. But you didn't think you were sipping something tied to cancer and infertility and immune damage and birth defects. And if you heard of PFAS, those forever chemicals, maybe you thought that was old news, something you didn't need to deal with, something that had already been dealt with. A lawsuit that, of course, already happened. But you didn't know that thousands of lawsuits are still working their way through the courts. You didn't know that 3M and DuPont are scrambling to settle for billions. Not because they didn't know the danger, but because they absolutely did. We as a people have to become more aware of this and stop being so complacent and assuming everything is done for us and safe. This is no longer our world. This mess here, it's not a regulatory oversight. This is chemical warfare by spreadsheet, my friends, and the EPA's failure to stop it is finally catching up. This is serious. This is one of the largest environmental mass torts in U.S. history, and it's still expanding. At the center are PFAS chemicals, per- and polyfluoroalkyl substances. I'm sure I butchered that. They are used to make nonstick pans, guys, and waterproof jackets, fast food wrappers, and firefighting foam. Pretty much everything. And once they get into your body, they don't ever leave, not for a long time, decades. They build up in your blood, in your organs, and your fetus. Here's the scandal. 3M and DuPont knew. Internal memos, some as early as the 60s, showing that these chemicals were toxic. And by the 90s, their own scientists were sounding alarms. But what did they do? They buried the research and denied the risks. They kept pumping it into products and letting it leak into water supplies across the United States. And now, in 2023, 3M agreed to pay over $10 billion to settle contamination claims from public water systems. But that was just the beginning. Now individuals and communities are suing for personal injury, even wrongful death, toxic exposure, claiming the chemical giants knowingly poisoned them. This is huge, guys. Our water, and you know what's going on with our food, poison there too. And while those civil cases churn, here's what the EPA has been doing, okay? They've been dragging their feet, allowing it to continue. The agency waited until 24 to announce enforceable limits for 6 PFAS compounds in drinking water. 6. Experts say it should have happened 20 years ago. Why are there any? Internal whistleblowers allege the EPA softened its recommendations under political pressure and corporate influence. So that is what is coming in and taking over your right to safety that was promised to you in your own country. So now the courts are doing what those regulators just wouldn't. They are forcing accountability. In 2025, in one case out of North Carolina, residents living near a DuPont-affiliated plant, well, they're suing for long-term health impacts. And the discovery process has already unearthed decades of cover-ups. Meanwhile, blood testing studies show that 97% of Americans, including our children, now carry PFAS in their systems. And guess what, guys? That includes you. Yep, because you drank water sometime in your life, and that stuff stays. You didn't opt in. You didn't get to vote on that. You were poisoned by design, and no one told you. I mean, you need to take this in. This isn't about pollution in the abstract. It's something that is inside of you right now and your kids and your friends, your unborn grandchildren. These things don't break down, okay? They are true forever chemicals. They resist water and heat and oil and time. But what they don't resist is your bloodstream. And once they're in, they stay and they accumulate. They start interacting with your endocrine system, your liver, your reproductive organs, and most studied variants, PFOA, PFOS, they have been linked to, get ready, kidney and testicular cancer, decreased birth weights, immune system dysfunction, thyroid disruption, increased cholesterol, and reduced vaccine response in children. We're not talking about rare cases, okay? This is national exposure. And why this isn't being talked about every single day. They're too afraid to tell you. According to the CDC, more than 97% of Americans now have PFAS in their blood, and that includes the newborns. Before they even take their first breath outside the womb. And this matters, guys, because you were never given the choice, and now there's nothing you can do about it. You didn't get to opt out of this. No one told you it was in your drinking water that you thought was safe, because at one point it was. No one told you your stain-resistant carpet came with a side of immune suppression. All these great products, guys, you might want to stop thinking they're all so wonderful. No one told you, or your community, that the firefighting foam your fire department used at the nearby military base, that would end up in your tap water and then in your veins right now. But 3M knew, and DuPont knew. They had the lab results. They ran the toxicity reports, and they made the spreadsheets. And then they looked away and just kept selling. This has been happening. This is why we do have Maha and Doge. Corporations are not just a nasty beast. They are doing things to you, even if you are trying hard to not be involved and look away. This is chemical colonization. It is serious. It's what happens when the cost of cleanup is higher than the cost of court. Bodies are changed forever. And here's why it's not over. While some lawsuits are landing, many of the most contaminated sites in America still have not seen a dime in restitution. And the federal government, including the EPA, they waited a whole year to create enforceable drinking water standards. After decades, of knowing. Let's just keep this clear. And even then, the limits are barely measurable. It doesn't mean they're cleaning it up. It means they're going to try to maybe do something about it. Most water treatment plants, they don't even have the technology to filter them out. Again, our systems are old. And that's why crimes are allowed to happen without us noticing. No one's funding any upgrades here. How do we think this is going to get fixed? The chemicals stay. The exposure continues, and the damage just adds up quietly, invisibly, and relentlessly. And this matters because the system did not fail. It actually performed like it was designed to protect industry over individuals. That's what's happened. Delay regulation until the evidence becomes undeniable, and until then, let the people get sick and die, and let's reap the benefits in profits. Try to settle out of court. Please, let's not tell anyone what's going on. Well, here's where we stand in June of this year now, 2025. We have thousands of personal injury lawsuits that are still working their way through federal courts under a judicial panel on multi-district litigation. MDL 2873, check it out, centered in South Carolina. The EPA's new drinking water rule, finalized in April of 24, sets the limit for certain PFAS at 4 parts per trillion. A vanishingly small number, but it does not yet mandate removal technology. Why is that? Why are humans expendable these days? Why is that? We get mandated to protect other things. Why can't we be protected? Even with all this going on, it's not enough. 3M, they're facing financial ruin from legal exposure. That is a big thing. They announced a complete phase-out of PFAS production by 26, but legacy contamination will remain in soil and water for generations. It's an ugly, ugly beast. Independent scientists and public health experts are calling for nationwide blood testing. We need this, expanded water monitoring, and a permanent federal compensation fund, none of which exists today. And here is the most chilling truth. Even after every lawsuit ends with a $1 billion settlement, even if the EPA tightens its standards and if PFAS are banned tomorrow, those chemicals are still inside of you. If you reproduce, still doing damage to you, still circulating, binding to proteins. It's showing up in breast milk, umbilical cords, the tissue of people who have never worked in a factory or lived near a chemical plant. What comes next is a reckoning. Not just in courtrooms, but in medicine, birth rates, cancer clusters, and generational health outcomes. We're only at the beginning. Damage is here, lawsuits are starting to catch up, but justice, in this case, is reactive, not preventative. And that's the lesson. The most dangerous toxins don't come with a warning label. They come with a trademark, and a PR department, and even a lobbyist. All right, so I've told you that these chemicals are forever, and that they're pretty much everywhere. But there are some contamination areas that are focal points in all of this, and I'm going to let you know what they are. Cape Fear River Basin, North Carolina. Industrial sources like the Chemours plant, contaminated drinking water used by Brunswick County and Wilmington. Toxins like PFAS detected at concentrations 1 ppb, that's 14 times what is advised. Hoosick Falls, New York. PFOA levels reached 540. That's 700% over the limit. Settlement exceeded $65 million, plus a 10-year health monitoring fund. Did you even know it happened? Or are we still talking about Michigan because they made a movie? How about East Metro, Twin Cities, Minnesota? All right, like Lake Elmo, Oakdale, Bayport. 3M dumping contaminated groundwater exposed 170,000 residents. Led to an $850 million state settlement back in 18. Bet you didn't hear about that. Lawrence and Morgan counties in Alabama, the Decatur area. PFOA, PFOS, contamination spiked unexpectedly in local water systems. I mean, this goes on. Michigan and Wisconsin hotspots like La Crosse, Parchment, Southeast hot zone, Alabama, Georgia, Tennessee. A major PFAS cluster spans Alabama, Georgia, Tennessee, covering numerous counties. Northeast corridor again, New Jersey, Pennsylvania, New York, Connecticut, Delaware. I mean, so many places, and people are not aware. This matters. These hot spots near industrial plants and military bases, wastewater sites, demonstrate that PFAS isn't just an abstract risk. It is very real in specific communities nationwide, for sure. Highlighting these locations transforms this into something out there to something that could be in your blood. They're in your tap water, guys. I mean, in places like Parchment, Michigan, and Hoosick Falls, New York, people found out too late that their water had been laced with chemicals. If I went and did that to my neighbor and killed them, I would go to prison. I mean, we're talking water laced at levels 10, 20, even 100 times higher than the EPA's advisory limits. In North Carolina, a river system serving hundreds of thousands was poisoned by a company that already knew the risks. 3M, Minnesota. Same operation. They still haven't cleaned up the groundwater. These are not isolated cases. These are systemic outcomes of an economy built on chemical shortcuts and a government that chose delay over protection. Remember I said that in the playbook? Delay, delay, delay. And if you think it's not happening where you live, you should ask to see the PFAS test results for your zip code. See if they even exist, because they should. All right. Hey, while we're all waiting, right, for Diddy and Reed, so much is happening. Off camera, there are still other things going on, real crimes unfolding. Thousands of women suing Uber, a Houston cop on trial for faking a warrant, a decades-long legal failure in the UK, and a multi-billion-dollar poisoning scandal that was not caused by a foreign enemy or some rogue terrorists, happened to you by your own. By the corporations we trusted, by the regulators we fund, the politicians we elect, and the silence we seem to tolerate when the lawsuits pile up faster than accountability. Yeah, we didn't need a lot of headlines for this episode. This episode is about what the headlines are hiding, because the justice system doesn't just operate in courtrooms. It operates in the shadows, in backroom settlements, in toxic tap water and redacted memos, in laws that come decades too late and blood tests that say it's already in you. Talk about panic. If you learned something today, share it, because the next time justice fails, it's not going to be televised. It's just not. It's going to be measured in micrograms, NDAs, and silence. So thanks for listening today to True Crime and the Court of Public Opinion. I am Alexis Knight, and you've just heard the truth behind the truth. Stay safe out there, guys. Ask the difficult questions and always demand the truth. Until next time.